Do you know that leaving behind inheritance for your loved ones may potentially fall in the hands of outsiders? Do you want to learn how to ring fence and preserve your client's inheritance for the next generation? Today, we are very privileged to have Marcus, who is also a partner at 𝘾𝙤𝙪 LLP. Marcus specializes in divorce cases and has a whole wealth of experience in this area. So Marcus, maybe why don't you share with us, how do you get into this area of law?
How do I get into this area of law? That's a very good question. I haven't considered it much, but when I first started doing law, there's a lot of ways to help people. And matrimonial law is one of those things where you can actually play a large direct impact in people's lives. What you do directly affects people's happiness,
right,
and affects their children as well. So you don't only help your clients, but you also help their children and anything else, so that when they move on from the marriage that ends, I think everyone can move on peacefully.
Right, exactly. Right. So today, our topic is really talking about how one can leave money behind to the next of kin or even to their children without falling into the hands of third parties. So we are in this area today. I think our audience are all glad and ready to listen to you. Why don't you just tell us more about what constitutes matrimonial assets?
Okay, I think it's very important for everyone to understand that matrimonial assets are the assets to be divided when a divorce happens.
Okay.
So matrimonial assets are generally assets that are purchased during the course of the marriage, right? Assets that you bring into the marriage before the marriage are not generally considered matrimonial assets. Likewise, assets from third parties or gifts, inheritance are generally not considered matrimonial assets.
Now, when you say generally, are there exceptions to that?
Yes, of course. So while it's not considered a matrimonial asset, it can be if certain steps were taken. So for example, when it comes to gifts and inheritance, if there was substantial improvement of this gift or this inheritance on the part of the other spouse, the court generally considers this to fall into the pool of matrimonial assets to be divided.
Wow, so in other words, inheritance may fall into the pool of matrimonial if the other party can prove that the asset has been substantially improved.
Yes.
Can you give us some examples of that?
There's a good case. I think what happened was, in that case, was that there was a supermarket chain owner, right? And he had actually gotten divorced in Singapore. He had gotten divorced in Singapore with his wife. Now, he had some shares from his father. It's not disputed, of course, that the shares were given during the course of the marriage. And in normal cases, gifts don't fall into the pool of matrimonial assets.
Right.
But because the wife had actually worked in the supermarket, she helped to contribute to the improvement in the value of shares. The value would not have been gotten if the wife had put in no effort.
So simply by just working in the supermarket
and helping to contribute, that helps to increase the value of shares, is sufficient.
And even if she's not a good worker?
Well, that's a bigger question, of course. I mean, if ultimately at the end of the day we can show that because of her contributions she decreased the value of the shares, then it might arguably not fall into the pool of matrimonial assets. But I think in this specific fact scenario, the court found that she was a good worker and she contributed to an increase in the value. Therefore, they're happy to let it fall into the pool of matrimonial assets.
Right, right. So there are cases that you have handled as well, or you have heard before, that inheritance to the next generation, for example, or even to the next of kin, will eventually or might fall into third parties if it's not being well planned for.
Yes, of course, there are many cases like that. We have to understand that while we try our best to plan and to leave things only to our children, right? Sometimes there's changes in circumstance that causes these gifts or inheritance to lose the quality of a gift and inheritance such that it falls into the pool of matrimonial assets.
Right.
Some common examples, of course, would be where other than substantial improvement, was where the property was used to improve the family.
Right.
Right. For example, if you have a property overseas, and then they use the property, the wife comes in or the husband comes in and renovates the property, devotes his time and effort to renovating the property, it increases the value of the property.
Even cleaning, doing housework.
Well, housework, if it's a de minimis, there's a principle called the de minimis principle. If it's so minor that it doesn't really introduce value, then no, it will not fall. So just because she cleans the house doesn't mean that she would suddenly acquire a share. But if she helped to renovate the house, Or if he helps to renovate the house, he finds the construction workers, he supervises them, then even though the house was a gift, it falls into the word matrimonial.
Right.
Yes.
So in this case, when we are talking about inheritance, potentially being ended up in a matrimonial pool of assets. So it's like, for example, a parent passes down a property to the son or to the daughter, and finally the daughter or the son gets married, and they decide to use that property for their matrimonial house.
Yes.
Right?
Yes, I know what you
because
mean.
because I'm thinking, if I am the beneficiary, I mean, I don't have a house to inherit, but imagine I would probably, and of course it falls on my lap, I'll probably just spend a couple of 100,000 or some money to door up the place, rather than take a queue to apply for BTO 4 to 5 years and probably in
whether you get it or not, it's a different question.
yeah,
right?
far away. I probably just shift in there. But when I bring in my spouse, you are saying that immediately turns into a matrimonial division if in the event of a divorce. Are you saying that?
Okay, there's exceptions to that, of course, but generally the property that you stay in is considered the matrimonial house.
Right.
Now, matrimonial houses are always subject to division, right? So it doesn't matter whether the house was a gift before or not, but once the property is in your name, and as long as both parties stay in the house, it becomes a matrimonial property. It's subject to be divided.
So is there a length of stay, like if you stay for less than a year, you don't have to put it under matrimonial, 2 years?
Now it becomes a bit more flexible. I mean, if it's a really short stay of a year or two, right, it's more open for you to argue that, hey, look, even though it was the matrimonial property, but it was actually a gift, and it shouldn't fall into the assets.
Right.
The court might be inclined to listen to the argument, but of course if you stay there for 15, 20 years, the court will say, look, no matter what it was before, it may have been a gift, but because by virtue of both parties staying there, raising a family there, it becomes a matrimonial property and it loses that quality of gift and inheritance.
Right, I like your point. Raising a family means you are intending to stay in that property.
Yes. So a more interesting problem will come about if you pass the property to your child, but it's held on trust by you, but your child and his wife stays there.
Right. So speaking about trust, so are there any other ways, or are there any ways to circumvent this area of estate planning? Because a lot of our audience, they have properties to pass down, and whenever I speak with parents, passing down properties to their children is like they don't need to learn any estate planning to know that they want to pass down the property. So is there any way you could probably educate or share with us how parents can do it in a more effective way, such that it can probably help to ring fence?
Okay. What I'll say is that when it comes to properties that you hand down to the children, if they already have a matrimonial property, right, it doesn't mean that every property you pass to them becomes a matrimonial property.
Right.
All right. But leaving that aside, if a property is held on trust, right, trust properties are not generally falling into the pool of matrimonial assets as well, because these properties don't really become their properties. They may not have the freedom to do these properties.
Right. So in other words, putting the property into a trust on behalf of the children, that would in a way help to ring fence.
Correct. So even though the property is eventually meant to be for the benefit of the children, right, as long as it doesn't become their property, or it's not in their name, right, or it's not intended to be in their name for maybe a very, very long time, right, then it's easier for the court to perhaps take the view that actually this property was not meant to be given to both parties, but meant to for only the benefit of the single child.
Right.
See?
Right. Okay. Are there any other ways that I remember you mentioned as well when we were chatting earlier? It really depends on how a particular individual would, in his will, to specify that it's to give solely.
Okay.
Yeah.
To make sure that a gift is really a gift, right? Sometimes wordings are important. You have to consider very carefully what words you put in your will, because that reflects your actual intention.
Right.
So if you are very specific with with an asset, say this property is meant to be given to my daughter absolutely, right? It makes it very clear that you are not intending for it to be given to both parties. But if you keep it very vague, like this property is meant to be given to my children, and maybe in the or something like give it to my children in the event that he gets married. Then it becomes very grey, because you meant to give it to your child, but you mean for it to be solely for her benefit,
Yeah,
for the benefit of the family, you see.
What about writing to give to my child? Absolutely. And then striking off any spouse, like, write it clearly.
Well, okay, ultimately we can't circumvent statute, right? Because statute is still the top in Singapore. So the statutes have made it very clear that, if it's a gift and an inheritance, no. But if there was substantial improvement, then unfortunately it will fall in the pool of matrimonial assets, because we cannot have one party put in their hard work into helping to improve the value of the property, but get nothing out of it.
Right.
So that's the whole rationale for the substantial improvement.
Right.
And therefore, if you are intending to give a property to someone, right, be it shares or maybe even a house, right, then it may be better for the property to either be put in the trust,
Understand.
where it's not really their property.
Yeah.
A lot of it depends on how you deal with it.
Yeah. I mean, exactly, I agree with you. Putting in a trust is a very clean, straightforward way that the property is not going to be vested in the child's assets.
And it's meant for this child's sole benefit, because if I say every month she will get to stay, she'll get 500,000 from this bank account, then the monies will always be hers solely, no matter how long or short the period is.
Right. And if anything happens along the way in a divorce of the children,
yes, the property doesn't suddenly become, this 500,000 must every month you receive becomes the family's money. No, it doesn't.
Yeah. So there's some form of ring fencing.
Yes.
I get you. Great. There's another area that most audience would like to ask. How about insurance policies? Take for example, for parents, they purchase insurance policies for the children, and in the event of a divorce, are those policies being part of the matrimonial assets to be divided?
Okay, when it comes to insurance policies, right, most of the time whenever you buy a policy, nowadays it's common to name the beneficiary, all right? So in that sense, any insurance policy that you buy for your children being the beneficiary, it's considered a gift to them. The reason why it's considered a gift to them is because the child doesn't generally put in money into the acquisition of the insurance policy. They don't pay for any part of it. So it doesn't fall into a pool of matrimonial assets. Especially if you name the beneficiary, you must have intended that in the event of your demise or something happens to you, these monies go to this beneficiary.
Right. So naming the beneficiary is key.
Yes, and I think now they require you to do so. And once you do it, right, it creates this situation where the policy benefits are only one person will enjoy the policy benefits.
Thank you so much, Marcus, for being here today.
And thank you for having me here, Eugene.
There you go. Today we have an exclusive session with Marcus, partner of Solid Air LLP, and today's topic is how to prevent your inheritance from falling into the hands of third parties. So if you like this episode, why don't you click subscribe below at the button or click share, and I'll see you in the next episode.